Hello everyone, welcome to Legal Darshan. In this video, it's a master video we are going to do today. It's a master discussion on Article 16 of the Constitution of India, and to be more specific on the reservation policy of India, on the affirmative action. We will start with case number 7 in this video today, and then we will go to case number, yes, and then we will go to case number 49, which is Jarnail Singh and others versus Lakshmi Narayan Gupta and others. And after discussing Jarnail Singh versus Lakshmi Narayan, we will be doing two more cases, which is State of Punjab versus Davinder Singh, and it is Janhit Abhiyan versus Union of India. Now, all the four cases in the list of AOR leading cases, which are numbered at 7, 49, 71, and 83. Now, all these judgments, the numbered at 749, 71, and 83, these are dealing with the reservation policy. Janhit Abhiyan, that is numbered at 71, is dealing with EWS reservation that is coming by 103rd Amendment Act in 2019. Seventh is the Indra Sawhney's landmark judgment, we all know as Mandal Commission judgment. On number 49, we do have Jarnail Singh, which is also famous as the reservation and promotion case. And on 83, we have the most recent judgment on State of Punjab versus Davinder Singh. State versus Davinder Singh, which is basically talking of sub-classification in SC/ST categories for providing of the reservation. Now, we will be traveling back from 1992 to 2004 in this journey, in which we will be discussing the cases with respect to reservation in India. Now, before we start ahead, I would like to open one article on the screen, which is Article 16 of the Constitution of India, because that will be important to have a look at in this journey, right? So I am just opening the article on my screen. Yes. Now, when we talk of Indra Sawhney's judgment, now the Indra Sawhney's judgment is one landmark judgment in the, history of reservation, history of affirmative action in India. It is coming in 1992 as a result of implementation of Mandal Commission's report. Now, what is happening in a brief background of the judgment is we are starting with the Indra Sawhney's judgment. Now, what is happening under PM Moraji Desai and during the VP Singh's government? What is happening basically that VP Singh's government is implementing the Mandal Commission report, which was given in which was a commission that was chaired by Mr. BP Mandal, and it was identifying the socially and educationally backward classes in India, which is SEBCs now. If you see the language of Article 15 and if you see the language of Article 16, the term used there is not OBC, but rather socially and educationally backward classes, which is SEBCs. Now, the Mandal Commission report makes a stunning revelation, that is that in India, more than 50%, which is approximately somewhere around 52% of the population, belongs to the backward class, and those population were highly underrepresented in the public employment. Now, it was held that in addition to the existing SC/STs reservation, which was somewhere around 21.5%, 14% for SCs and 7.5% for OBs for STs, it was said that 27% of the reservation should also be added for people belonging to SEBCs, which is socially and educationally backward classes, and provided a 27% of reservation in central government, in the government jobs, in the public employment, as well as in the educational sectors, educational institutions, which meant basically that the reservation spiked up to approximately 49.5% or 50%. Now, the moot question that is coming here in before the bench in Indra Sawhney's judgment is that to what extent is such thing legal. Because in 1990, the then Prime Minister VP Singh is implementing the Mandal Commission recommendation through an office memorandum, which sparked the nationwide anti-reservation protest. Now, even if we see this today, there are number of protests that comes in the picture whenever there is a reservation provided. Even if we look at the EWS judgment, EWS judgment is also a response to the nationwide protest that is happening as in against the EWS reservation that was granted by 103rd Amendment. Now, this battle is reaching the Supreme Court. This nationwide protest that 27% of quota has been granted to SEPCs, it is reaching Supreme Court, where a nine judges bench is expounding on the issues that are framed before it. Now, basically, in this case, the main question was that whether such reservation is valid, whether that is a violative of Article 16, which is guaranteeing 16 clause 1, which is guaranteeing equal opportunity in employment, and whether this 27% reservation is valid, and whether there was a previous case of MR Balaji, so that MR Balaji is providing that up to 50% reservation can be granted in public employment and educational institute, whether that 50% MR Balaji limit that is provided in MR Balaji, is it a valid limit or it needs to be amended, right? And if reservation is there, will it be applying to promotion cases? What will be the fate of promotion cases if we, go to it? Now, the court herein is holding, in the case of in the case of Indra Sawhney, the court is basically holding that, yes. So I'm just scrolling down to the judgment part. Just pardon me for a second. So this is a brief history that I am, traversing through. It is talking of Kaka Kalekar Commission. It is also talking of the Mandal Commission, and when the Prime Minister VP Singh is issuing the memorandum. Now, the court in this case is looking at the, contestations that have been made. So now court basically, just a minute, we will come to the judgment part and then we will resume the discussion. Yes, so there are many issues that have been framed in this judgment, and this judgment is being decided by a nine judges bench. Now, yes, these are the verdicts that have been given in the case of Indra Sawhney. So basically, what is happening in this case is, now court is looking at the implementation of the OM order by the then Prime Minister VP Singh, and the court is basically deciding by a 6:3 majority that the validity of 27% reservation for SEBCs is valid, but then it will be subject to some constitutional limit. Now, court in MR Balaji, because this case goes back to MR Balaji versus State of Mysore's judgment also, and in MR Balaji, it was held that caste cannot be a sole criteria for determining backwardness. But now in this case, the Indra Sawhney case, the court is basically overruling MR Balaji to the extent saying that caste can be a sole criteria in determining backwardness. But however, to claim reservation under such policy, under such affirmative action, your backwardness needs to be social and educational in nature, because the term used there is socially and educationally backward classes. Now, it should not merely be economical. Economical parameters shall not be considered to the full extent when backwardness has to be determined by social and educational parameters. Now, this in Indra Sawhney, what is happening? Court is upholding 27% OBC reservation, SEBC reservation in educational institutes as well as in the public employment. But court is bringing out the concept of creamy layer. Court is also noticing the fact that some members of the class, socially and educationally backward class, are falling in the creamy layer because they are economically advanced. So when they are economically advanced, they can be excluded from the reservation benefits, right? So the court herein is basically dividing Now, the court herein is basically dividing SEBCs into two classes, which is creamy layer and non-creamy layer. So whenever you apply for certain exams, or whenever you apply for jobs, apply for admission, there is always a column when we read OBC NCL as a category, which is reserved. Because the creamy layer OBC or the creamy layer as SEBC, which who are economically advanced, who are earning good amount as decided by the policymakers at that time, those people are not considered to be SEBCs for the purpose of granting them reservation under Article 16, Clause 4. Because articles, if you look at Article 16, Clause 4, yes. Article 16, Clause 4 says that nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens which, in the opinion of state, is not adequately represented in the services in the state. So now this particular backwardness may belong to SCs, STs community, and it can also belong to SEBC community as well, right? So now, yes. Now, when we go back to what was held in the judgment, is that it agreed with MR Balaji to the. Now, it is partially overruling MR Balaji's judgment. It is partially upholding MR Balaji's judgment also. Now, MR Balaji is overruled to the extent that caste cannot be a sole criteria in determining social and educational backwardness. But in Indra Sawhney, we are saying that caste can be a sole parameter in determining social and educational backwardness. And it is upholding MR Balaji to the extent that total reservation should not exceed 50%. 50% given to be upper CL for the reservation in by the case of Indra Sawhney. Now, coming to the question of promotion, that whether there are reservations allowed in the promotions, that once a person is appointed, will reservation be also given in the cases of promotion? Indra Sawhney is answering that particular question in negative and saying that reservation in promotion is unconstitutional under Article 16, Clause 4, as so says the language of the court, language of the constitution. And also, court is also saying that once you are identifying the backward classes, what classes constitute backward classes in the purview of Article 16, Clause 4, that identification is also subject to the judicial review. That is something which also is being highlighted in the case of Indra Sawhney versus Union of India. Now, this judgment, as I was saying above, it is also known as the Mandal Commission case, because it is coming as a consequence of Mandal Commission. Now, what happens that whenever judiciary decides something and Parliament wants to go in a nature of overriding it, they do an amendment. So as a result, 4A amendment, 4A Article 16 4A is being inserted by the 77th Constitutional Amendment Act, and it overrode the effect of Indra Sawhney's judgment to the extent that reservation can be given in the matters of promotion with consequential seniority, as was developed later on in the cases, right? So that 16(4)(a) is basically strengthening here that reservation in promotion can also be given, right? Now, after Indra Sawhney, in Ashok Kumar Thakur, all of these amendments are getting challenged. And next what comes is the case of M. Nagraj versus Union of India. Now, M. Nagraj case is not there in M. Nagraj case is not there in the list of leading cases for the AOR examination, but because there is a case of Jarnail Singh versus Lakshmi Narayan Gupta, we need to discuss the case, because Lakshmi Narayan Gupta is basically based on M. Nagraj case only. Now, what is happening in M. Nagraj case? We will just discuss the law point here. So, in 2006, court is again faced with the constitutional validity of amendments that is allowing reservation and promotion for SC/STs and backward communities. Now, Supreme Court in M. Nagraj is upholding that reservation and promotion is valid, but there are three conditions that should be fulfilled. Number one, that there should be that you should prove that there is a backwardness. So some quantifiable data has to be used to prove the backwardness. Now, three conditions have been laid down in M. Nagraj judgment, and I am showing the screen for 49th leading case, which is Jarnail Singh versus Lakshmi Narayan Gupta. Now, Supreme Court in M. Nagraj is basically upholding that backwardness of SC/ST community is to be proved, that they are currently, when they are taking the employment, they are still in the backwardness, and it must be proved that there is an inadequate representation of such community, and it should be ensured that administrative efficiency shall not be affected, and administrative efficiency shall be maintained by by bringing an effect to these amendments, or by effectuating these amendments. Now, this judgment was basically this M. Nagraj, when the Supreme Court is, looking at M. Nagraj, issuing such kind of direction in M. Nagraj judgment, it has been criticized that when we have already acknowledged that SCs and STs have a historical backwardness proved, the Constitution itself is acknowledging there is a backwardness, it is a backwardness in the status of SC/ST communities, then why do we need to reprove it just to gain the promotions or gain the reservation in promotions? So that particular questions comes before the challenge in the case of Jarnail Singh versus Lakshmi Narayan Gupta, and now the court is revisiting the case of yes. Now the court is revisiting the case of M. Nagraj versus Union of India. Now it was a demand that larger judge bench reference should be given, but court, however, is denying that reference. Now, what is happening in the case of Jarnail Singh versus Lakshmi Narayan? It is basically yes. So now in this case is also known as reservation in promotion case, and it is being decided by a 5 judges bench. And 5 judges bench unanimously it is finding that the judgment delivered in Nagraj judgment, it is not a very good law that has been upheld in the Nagraj. So it is striking down the demonstration of backwardness, of the current backwardness of the SC/ST community. Now, what is basically held in the case of Jarnail Singh versus Lakshmi Narayan. Now, the court is partially overruling M. Nagraj judgment and saying that the first condition that is to be satisfied for granting SC/STs or backward classes promotions, reservation in promotion, is that SC/STs need not demonstrate their backwardness. Okay, so in M. Nagraj, there was the first condition that they need to demonstrate that they are really backward at the time of claiming the position. But in the case of Jarnail Singh versus Lakshmi Narayan, it has been said that Constitution itself acknowledged that there is a certain level of backwardness due to historical discrimination, or due to due to the discrimination that has been faced by the people of those communities. And thus, when their status itself is constitutionally defined, SCs and STs do not need to prove their backwardness again and again. But however, the court is upholding that yes, inadequacy of representation can be one condition to check to provide reservation in promotion, and administrative efficiency should also be checked. Now, the last 2 conditions are upheld, but then it was also upheld that last 2 conditions were upheld. It was said that once you are checking, once the backwardness examination of backwardness condition number 1 condition was abolished, but it was upheld that you need to establish, that there is an inadequate representation of the community in the relevant sector, and that when we are providing such reservation, it will maintain the administrative efficiency. Now, the judges in this court, in this case, are also looking at the case of Indra Sawhney, because in Indra Sawhney, the Indra Sawhney's judgment, it is saying that further backwardness need not be proved in the case of SC/STs, and Indra Sawhney is not allowing for collection of quantifiable data as a prerequisite for granting a reservation, especially in the case of promotion. Now the judgment is modifying further backwardness criteria. Judgment is basically saying that SC/STs do not need to prove that they are backward at the time of claiming the position, at the time of applying for the reservation that is granted to them in promotion. It is also saying that there will be a creamy layer exclusion that will apply to SCs and STs for the matter in reservation. So creamy layer concept herein in the case of Jarnail Singh is introduced for SCs, STs who are claiming reservation and promotion as well. Now the court herein is saying that why are we extending creamy layer exclusion is because creamy layer exclusion is a principle of equality. It basically helps that if you do not apply the exclusion of creamy layer principle, it is going to violate the right to equality. It is because you know uh, it is basically that if you treat unequals the same, basically if you are treating unequals in the same manner, which is backward classes and the forward among backward classes in the same manner, then the one who is more backward is left aside. He's there is no equality for him as well. Therefore the exclusion of creamy layer principle is essential to safeguard the right of equality, even in the same categorization or homogeny of people, right? So now justices in this case are observing that the whole object, they are basically looking at the ethos of the ethos of the reservation, and they are basically saying is the whole object is that the backward classes move forward so that they can join hand in hand, they can come hand in hand with the other citizens of India. The opportunities should be extended to them equally, and that will not be possible if only the creamy layers are being promoted, are going above and above. They are first coming in the jobs and then seeking promotions. We need to make a balance that the one who is more backward should be provided further support, because in Indra Sawhney it was held that there is a distinction between backward and more backward. That is why we were coming at a concept of creamy layer and non-creamy layer, and therefore it should also apply to scheduled caste and scheduled tribes as well. But however, it will not tinker with the powers given in the president under the presidential list given under Article 341 and 342 of the Constitution of India, right? So the bench herein is clarifying that the creamy layer principle is also a principle of equality, because it is substantiating equality, and it is not basically just letting equality be an idealistic approach, but also implementing it in the form of substantive equality. Now the key takeaways from the judgment of Jarnail Singh is that there was there was number one, the backwardness that needed to be proved, demonstrated, that condition was struck down. And then another thing that is there is that the exclusion of creamy layer principle shall also apply to SC/STs in the case of reservation and promotion. Now, this case partially overruled M. Nagraj judgment, but it retained that there is a requirement of having quantifiable data for inadequate representation. Inadequate representation in that job sector, and not the inadequate representation of the community, right? So inadequate representation of the community in that job sector needed to be taken into account, provided that there is a compliance with administrative efficiency also. Now, this was the case of Jarnail Singh versus Lakshmi Narayan. Now, coming on to the most recent case, which is the 2024 case of 2024 case of State of Punjab versus Davinder Singh. Now, the issue that is coming before the consideration of the bench in this case is about sub-classification of the SC/ST communities. Now, what is happening in Punjab? There are two communities which are given specific quota. These communities are Valmiki and Mazhabi Sikh communities, and the case is basically dealing with sub-classification among scheduled caste. And the question herein is that whether certain communities like Valmiki community and Mazhabi Sikh community, can they get their fixed share within the SC reservation quota? So now, what is happening in this case is that basically this is the total position. Let's say total position are 100, and 14 positions are reserved for the SCs, and out of 14, these six position, or let's say seven positions, are reserved for the people belonging to Balmiki and Mazhabi Sikh community. Now the court here, now what is in challenge herein is that if you see, there is a sub classification happening within the SC community. Now the question before the court to determine is that whether such kind of sub classification is permissible, because in the earlier precedent decided by the Supreme Court, E.V. Chinnaiya, Supreme Court has held that no sub-classification is possible among the SCs community, and they must be, treated as a homogeneous block. But in this case, it is a seven judges bench judgment, and 6:1 is the majority ratio. Justice Bela M. Trivedi sitting in the dissent. The court herein is saying that sub-classification is constitutionally valid even in the case of SC/STs communities as well. Okay, the court herein is holding that Article 341 recognizes SCs at national level, but state can make equitable reservation measures so that the benefit reaches to the person who deserves it the most, who is the most backward. Even in the backward classes, the benefit should be given to them. So Justice Gawai in this case is also advocating that we can also bring NCL concept, CL and NCL, creamy layer and non-creamy layer concept in administration of affirmative action for SC/STs communities as well. Now the court herein is also acknowledging that there are some castes. Okay, there are some castes within the scheduled caste also that have concerned, that have basically, the concern is that those castes have been cornered, that those castes have been cornered from with a disproportionate share of the benefits. Now there are some categories which are having all the benefits, generation after generation they are going into the services, but then there are some communities within the SC caste itself, which within the SCs itself, which are not getting the benefits, and they have been cornered. So now we can also invoke the equality principle here. We can also invoke the more backwardness principle here, that the community is backward. We are understanding that there is a backwardness status given to them by the constitution. But herein the courts are saying that there can be more backwardness in the backward communities as well. And to uplift those more backward people, sub-classification comes out as a tool. And therefore it is supported that creamy layer concept can be used to filter out the advanced group even within the SCs and STs communities. And reservation should be extended in proportion to the one who are more backward and who need it more, so that an equitable distribution of reservation policies can be made. But however, Justice Bela M. Trivedi is dissenting here, and she's warning that the judgment can bring a violation to Article 341, which is providing that only Parliament can modify the SC list. So state do not exercise that power, but the majority opinion is allowing so in the ends of substantive justice. Now, the fear that is being expressed in the dissenting opinion by Justice Bela M. Trivedi is that it can, fragment constitutional integrity or constitutional morality as well. However, when we look at this judgment overruled E.V. Chinnaiya and said that a more nuanced affirmative action policies can be considered for intra-group disparities, right? So this judgment is basically going by the ratio of 6:1. And when we look at this judgment, it is marking a very significant shift in the Indian reservation jurisprudence by permitting subclassification within the SCs and STs communities. And it is also pointing towards endorsing the creamy layer principle. Now, the creamy layer principle can be applied to SCs, STs. We have discussed in the reservation cases. Now, reservation and promotion case, which is the Jarnail Singh case, is also dealing about it. Now, the judgment is, lauding substantive equality. It is also raising some questions about fragmentation within the SCs, STs communities. And the challenge remains that, whether such subclassification can be implemented effectively, or then there will be some procedural lacunas and so. Now let's come to the EWS judgment, which is the 71st which is listed on 71st number in the list of AORDD cases and goes by the title of Janhit Abhiyan versus Union of India. Now, this judgment is also known as EWS judgment because it is basically examining the constitutional validity of 103rd Amendment Act. Now, when we look at what 103rd Amendment Act did, it inserted a clause 6 in the Article 15 and Article 16. Now, what clause 6 is that nothing in this article shall prevent the state from making any provisions for the reservation of appointments or posts in favor of any economically weaker section of citizens other than the class mentioned in clause 4 in addition to the existing reservation and subject to a maximum of 10% of the post in each category. Now, basically, your Article 16 clause 16 clause 6 and 15 clause 6 are talking of providing 10% of reservation for economically weaker section in admissions to educational institutes and also in appointment in the government jobs or public employment, basically. Now, what is happening in this case is that this economical reservation is basically given on the sole criteria of economic sole economic criteria, and it is just being applied for the people who are not SCs, STs, or SEBCs. So all the backward communities, all the SCs and STs communities are being left out of the benefit of the EWS quota. Now, EWS is basically the quota that is given on sole economic basis, and the seats reserved are the 10% of the seats which are notified in the public employment or the education sector, right? Now, this amendment is being challenged. 103rd Amendment that has been passed by the Parliament, it is being challenged, and it is the question herein is arising that whether the 103rd Constitutional Amendment is valid, because in the views of petitioner, it violates the basic structure doctrine, it violates the principle of equality or the structure of affirmative action also. And the second question is arising that whether economic criteria can be a sole basis of granting reservation, because in Indra Sawhney we have discussed that it cannot be a sole criteria. And third, that when you are excluding SCs, STs, and OBCs from the EWS reservation, is it constitutionally valid? Or in a way, are you denying that one who is belonging to SCs, STs, and SEBCs communities cannot be, economically backward? Is that an implication of this judgment? So now the case, because we are questioning that when you are excluding SCs, STs, and OBCs or SEBCs from the EWS reservation, which is meant for everyone, because a person can be belonging to economically backward class, and he can also belong to SCs, STs, and OBC class. So why are we excluding SCs and STs and SEBCs? Does not it amount to exclusion? Does not it amount to discrimination, violating the basic structure, violating the principle of equality? And when we are adding 10% of the reservation, isn't it in the breach of the rule laid down in the case of Indra Sawhney, because the reservation now will exceed 50%. So now the issue that is for the determination before the court is that whether the 50% cap that is, upheld in the case of Indra Sawhney, 50% ceiling limit, it is binding, or it can be made flexible. Now, what is the impact of the judgment herein needs to be analyzed? Is it shifting the focus of reservation from historic and systematic oppression to the transitional economic criteria, and thereby undermining the constitutional goal of social justice, right? So now in this case, this judgment is being authored by the judges, and majority opinion is being rendered by Justice Maheshwari, Justice Pardiwala, Justice Bela M. Trivedi, and those are basically holding that amendment is valid and it does not violate the basic structure doctrine. So they are also upholding that economic criteria can be a sole criteria for granting of the it can be a sole criteria for granting of the reservation. Now, however, Justice UU Lalit and Justice Ravindra Bhatt, they are putting in a dissenting opinion. Now, what the majority view is about. Now the majority view is basically saying that constitution has previously recognized only social and educational backwardness, but economic weakness is also a form of disadvantage. Now this amendment is not, obliterating the existing quota system for SCs, STs, and SEBCs, but it is also creating a separate classification for entirely different class, that is the EWS community. Now, what is happening that the creamy layer doctrine is not applying here because, of course, EWS is not class based; it is economic based. Now, to the question that whether it violates the basic structure doctrine, the court herein is holding that basic structure doctrine does not prohibit classification basis economic criteria, because constitution does not promote formal equality but rather includes differential treatment to equalize opportunity, and this is one measure of doing so. Now Justice Bela M Trivedi is also concurring with the majority opinion. She is saying that affirmative action is a means of promoting distributive justice, and economic disadvantage does need recognition, and economic inequality is most pressing form of deprivation these days, and some kind of measures need to be made for them. Now 103rd amendment, it is not exclusionary, it is simply avoiding overlapping entitlements. That is what has been said by Justice Bela M Trivedi, that we cannot extend double benefits in EWS as well as in SCs, STs, or SEBCs quotas to the people. It's better that we keep the economic criteria separate, avoiding the overlapping entitlements. Justice Partiwala is also, seconding such opinion and saying that reservations should not be, of course, permanent in nature. They should be transient. They should be, modified according to the time, and that's what the essence of the judgment goes like. But however, there are two judges who are showing the dissent herein, that one thing we need to note, that reservation is not an end but a means to an end, and it should not be allowed to become a vested interest. That is one takeaway from the judgment. But when we are talking of the dissent given by Justice Bhatt and Justice Lalit, they are saying that, Justice Yu Lalit, they are saying that 103rd amendment violates the basic structure doctrine because it is excluding the SCs, STs, and OBCs from the EWS quota, because we cannot rely solely on economic criteria, which was also held by a 9 judges bench in the case of Indra Sawhney. Now, the conception of affirmative action is basically rooted in history. The systematic oppression, the structural discrimination, the caste oppression that has happened. Economic disadvantage is fluid. Somebody can be rich today and poor tomorrow, and again become rich uh, become rich the day next. Now, economic disadvantage is fluid. It has fluidity in it, but unlike caste-based marginalization, caste goes deep rooted in a society, and therefore there is a systematic and historical entrenchment there. EWS is a legitimate action that is being taken in the form of affirmative action. But however, when you exclude those who are already disadvantaged, that is constitutionally impermissible and a violative of basic structure doctrine as well, and it violates the substantive equality too. Also, there is an implication that state cannot over legislate reservation, and it is constitutionally implied from Indra Sawhney that if over legislation of reservation is done, it also threatens equality. Now, 3-3 is to 2, again, the EWS reservation was upheld. The significance lies in the fact that economic deprivation is also considered as a ground for reservation. It opens the door to non-caste based affirmative action, also making economic weakness a ground. But however, it raises concerns about dilution of original goals of the reservation. And also, when we look at this judgment, we can say that the question that whether Indra Sawhney's 50% upper seal, it is flexible or it is rigid, the answer lies in the fact that it is not rigid but can be modified as per the transient nature of the need arising in cases of reservation. Now, this is it for the discussion. It was a lengthier discussion, I understand that, but then it is covering the 4 cases for you in the list of your leading cases. I hope the discussion is useful for you. Please stay tuned with Legal Darshan for more such videos. Thank you for watching. Have a nice day.